All right, welcome to another episode of Mike Reads. Today we'll be continuing in our series on Thomas Sowell's Discrimination and Disparities with our second read in Chapter 3 entitled Sorting and Unsorting People. Today we will begin reading the subsection entitled Unsorting People. So let's begin. The residential and other outcomes produced by the sorting of people became, in the second half of the 20th century, widely condemned as wrong in itself, and as creating other social wrongs against the less fortunate groups. This might be considered a special case of the more general assumption that outcomes would tend to be even or random in the absence of malign intervention. But whatever it was based on, the view became axiomatic among many Americans in the second half of the 20th century that unsorting people was a high priority, especially in schools, but also in residential neighborhoods. Educational unsorting. Perhaps the most famous and most consequential Supreme Court decision of the 20th century was that in Brown v. Board of Education in 1954, declaring that racially segregated schools were unconstitutional. This ended more than half a century of hypocrisy following the 1896 decision in Plessy v. Ferguson that government-imposed racial segregation did not violate the Fourth Amendment requirement of, quote, equal protection of the laws, end quote, for all, so long as the racially segregated facilities provided for blacks were, quote, separate but equal, end quote. For generations, it was widely known that the separate facilities provided for blacks in the racially segregated South were grossly unequal. As courts belatedly began to demand that either equal state institutions be provided for blacks or else blacks must be admitted to the institutions provided for whites, various efforts were made by southern states to reduce the inequality, and in some cases, blacks were reluctantly granted access to some white institutions, such as a law school in Texas, though with restrictions that did not apply to white students. But even this represented a slow, uphill advance against determined resistance by Southern officials. Now, in the Brown v. Board of Education case, a unanimous Supreme Court decreed that racially segregated schools were, in Chief Justice Warren's words, inherently unequal, so that the slow and circuitous route to equalizing government facilities was to be replaced by simply outlawing the official sorting of school children by race. It was now no longer a question of unequal physical facilities or unequal financial support, for the very act of racial segregation was said to reduce the educational prospects of black children. Quote, to separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. End quote. In the heady atmosphere of the times, where the Brown v. Board of Education decision was widely hailed by blacks and most whites alike, except among white Southerners, as a long overdue end to government-imposed racial segregation and discrimination, the ringing assertions made by Chief Justice Warren were widely accepted. Nevertheless, only about a mile from where those pronouncements were made in the Supreme Court, there was an all-black public high school whose history, going all the way back into the 19th century, belied the Chief Justice's key assertions about empirical facts. As of 1954, when Chief Justice Warren declared that separate schools were inherently unequal, all-black Dunbar High School sent a higher percentage of its graduates onto college than any white public high school in Washington. As far back as 1899, when the same tests were given in Washington's 4 academic high schools at that time, this same all-black public high school scored higher than 2 of the 3 white public high schools. Although most of its graduates went to local colleges, some were already beginning to go to some of the leading colleges in the country at the end of the 19th century and graduating Phi Beta Kappa. Over the period from 1892 to 1954, 34 of these graduates were admitted to Amherst College. Of these, 74% graduated from Amherst, and 28% of these black graduates were Phi Beta Kappas. Among other elite colleges from which students from this high school graduated Phi Beta Kappa during that era were Harvard, Yale, Williams, Cornell, and Dartmouth. Among the graduates of this high school, known by various names over the years since its first founding in 1870, including Dunbar High School since 1916, were, quote, the first black who, end quote, had a range of career achievements. These included the first black woman to earn a PhD at an American university, the first black federal judge, the first black general, the first black cabinet member, the first black tenured professor at a major national university, and Dr. Charles Drew, who won international recognition as a pioneer in the use of blood plasma. Clearly, racially segregated schools were not inherently inferior. There is no question that most black schools in the South at that time, and many in the North, had inferior educational outcomes. And no doubt inferior resources supplied to black schools had a role in these outcomes, though not necessarily the sole role or the most important role. In any event, the crusade to racially integrate public schools during the decades following the Brown versus Board of Education decision generated much social turmoil, racial polarization, and bitter backlashes, but no general educational improvement from seating black school children next to white school children. One of the painful ironies of the racial integration crusade was that Dunbar High School's 85 years of academic achievement came to an abrupt end in the wake of Brown versus Board of Education. To comply with that decision, Washington schools were all made neighborhood schools so that Dunbar could no longer admit black students from anywhere in the city as it had before, but only students from the particular ghetto neighborhood where it was located. Dunbar quickly became a typical failing ghetto school with both academic and behavioral problems. By 1993, a smaller percentage of Dunbar students went on to college than had done so 60 years earlier, even though 1933 was in the depths of the Great Depression of the 1930s, and 1993 was in the midst of the prosperous decade of the 90s. Neither racial integration nor general prosperity, nor even a newer, more modern, and more costly school building was a substitute for what was lost. Yet, toward the end of the 20th century, some new and highly successful schools brought educational excellence back to many ghetto communities, not only in Washington, but also in New York and other communities across the country. Many of these educational successes were in particular chains of charter schools, such as the Success Academy and KIPP, Knowledge is Power Program, KIPP, chains. Not all charter schools were successful, but those that were successful often produced a level of educational achievement far above those of either most ghetto schools or many of the white schools to which black children were bussed in the name of racial integration. Because these highly successful charter schools were often located in low-income black or Hispanic neighborhoods, the demographic makeup of their students was seldom what racial integrationists were seeking. But, nevertheless, educational tests showed that the academic level of students in some of the more successful charter schools located in black ghettos scored well above the national average. In 2013, children in the 5th grade in one of Harlem's schools in the Success Academy chain, quote, surpassed all other public schools in the state in math, even their counterparts in the whitest and richest suburbs, end quote, according to the New York Times. Nor was this an isolated fluke. In 2014, children in the Success Academy chain of charter schools as a whole scored in the top 3% in English and in the top 1% in math. Although successful charter schools have often been located in low-income minority neighborhoods, and often in the very same buildings where the regular public school children score far below the national average, the successful charter schools are not destroyed by their location, as Dunbar High School had been when it became a neighborhood school. Unlike other public schools, charter schools are neither required nor authorized to enroll all the students in their respective neighborhoods. Students are admitted to many or most charter schools by lottery, while most of the local students end up in the regular public school in their neighborhood. Although admission to these charter schools is by chance rather than by ability or performance, there is nevertheless a self-sorting of parents and students, with only those parents who want a better education for their children, and only those children willing to subject themselves to a more demanding regimen of schoolwork being likely to seek admission. Here, as with Dunbar High School during its past era of academic achievement, self-sorting was crucial. Black students were not simply assigned to go to Dunbar High School. They had to apply, and those with neither the interest nor the inclination to subject themselves to rigorous educational norms had no reason to apply. The educational track record of such self-sorting has been far more successful than third-party sorting, whether the third party sorted by race or by residential location, or by a belief that racial diversity would lead to higher educational achievements. The self-sorting found among other groups in countries around the world is denied to American blacks when their children are all lumped together, whether by race in the days of the racially segregated South, or by residents in public schools with monopolies in their respective districts. Internal differences have been at least as common among blacks as among other racial or ethnic groups, making self-sorting a way of reducing counterproductive frictions that impede education. Successful charter schools give a glimpse of what can be accomplished by black children in low-income ghettos when self-sorting frees them from the disruptions and violence of unruly classmates, just a small number of whom can prevent a whole class from getting a decent education. Residential unsorting. Along with the unsorting of American school children by decades of mandatory busing to racially, quote, integrate, end quote, public schools in racially different neighborhoods, there have been parallel efforts to racially integrate the neighborhoods themselves. Among the various government programs to unsort people who have sorted themselves have been programs to build the kind of housing in middle-class neighborhoods that would be affordable to people with lower incomes. Other strategies have included providing subsidies to enable low-income and minority families to be able to rent existing housing in higher-income neighborhoods. The assumption behind such programs has been that social isolation was behind many social pathologies in the ghettos, so that ending that isolation would lead to improvements in the behaviors and in performances of minority adults and children. This was essentially the same assumption behind the Supreme Court's Brown v. Board of Education decision that separate facilities were inherently unequal. Although that decision did not explicitly state that racial mixing was essential for black children to get an equal education, that was the logical corollary of what the decision did say. The idea of racial integration or demographic diversity spread from education issues to questions of residential unsorting of different racial, ethnic, or income groups. Government promotion or imposition of such policies was said to benefit both the newcomers inserted into middle-class neighborhoods and the existing residents who had sorted themselves away from them. Whatever the plausibility of these assumptions and theories, the crucial question of the empirical validity of these assumptions depends on hard evidence. Contrary to those who attribute social pathologies in the ghettos to external causes in general, and white racism in particular, some of the strongest opposition to government programs that insert black people from ghettos into middle-class neighborhoods came from black residents in those middle-class neighborhoods. As the Chicago Tribune put it, quote, "The harshest criticism of dispersing public housing's tenants comes not from whites but from blacks. In Harvey, a struggling, working-class African-American suburb south of the city, nearly 1 of every 10 housing units is already occupied by renters with subsidies." End quote. Among the behaviors of the newcomers commonly complained of by the original residents of working-class and middle-class neighborhoods around the country are that the newcomers' teenage children, quote, are allowed to hang out on corners, play basketball late into the night, and sit in parked cars blasting profane music, end quote, as in Chicago. According to pre-existing residents, quote, they hear frequent gunfire, end quote. In a San Francisco Bay Area community, The charge is that the children of the newcomers were, quote, burglarizing nearby residences, hosting wild parties during the week and weekends, threatening neighborhoods, and engaging in various forms of criminal activity, robbing and assaulting our kids to and from school, end quote. In Louisville, homicides have remained concentrated over the years in areas where housing project people have been concentrated. Black residents in working class or middle class communities have been particularly uninhibited in their denunciations of people from housing projects and people on welfare that the government inserts into their communities, perhaps because black middle class residents are not afraid of being called racists. According to the Chicago Tribune, the resistance of working class and middle class blacks, quote, in some cases has been fierce, end quote. Black homeowners have, quote, protested loudly, end quote, at public meetings that they, quote, didn't want those people moving back into their rejuvenated neighborhood, end quote. Often homeowners at public gatherings, quote, would shout at officials that they'd worked hard to get where they were and that they didn't want to live next door to people who would just tear up their homes. They called them project people, lowlifers, and freeloaders, end quote. Quote, some blacks feel that those people make it tough on those of us trying to make something of ourselves, says Shirley Newsom, a homeowner in Kenwood, Oakland, and a longtime voice of moderation. That's why white America doesn't want me living next to them, because they look at me and figure I'm from a place like public housing, end quote. Like so many social patterns that are usually discussed in terms of race, this pattern of inserting underclass newcomers into neighborhoods where they are resented by the pre-existing residents also exists when the underclass newcomers are white and are resented by white pre-existing residents. In the best-selling memoir, Hillbilly Elegy, the author, a white man from a hillbilly background, reported that his grandmother saw the government's placing underclass people in their midst, quote, as a betrayal, ensuring the bad people would move into the neighborhood, end quote, even though they, quote, looked a lot like us, end quote, but they were the kind of hillbillies who, quote, gave our people a bad name, end quote. Among other things, she resented, quote, the drugs and late-night fighting, end quote, among the new neighbors that the government had placed in their neighborhood, and she said of the woman who lived next door, quote, she's a lazy whore, but she wouldn't be if she was forced to get a job, end quote. More pointedly, quote, I can't understand why people who've worked all their lives scrape by while these deadbeats buy liquor and cell phone coverage with our tax money, end quote. Advocates of unsorting neighborhoods, whether by race or by class, argue that living in a better neighborhood will produce benefits for both the adults and the children who are moved in, and benefits of diversity for society at large. But these expected benefits to the newcomers from housing projects and high-crime neighborhoods have repeatedly failed to show up in extensive empirical studies by a wide variety of researchers on the federal government's Moving to Opportunity program. A study of that program published in the Journal of Human Resources concluded, quote, we did not find evidence of improvements in reading scores, math scores, behavior or social problems, or school engagement overall for any age group, end quote. Another study of the same program, published in the American Journal of Sociology, concluded that, quote, there is no evidence that extra time spent in low-poverty integrated neighborhoods improves economic outcomes, end quote. Yet another study of the Moving to Opportunity program, published in the economic journal Econometrica, likewise concluded, quote, we found no significant evidence of treatment effects on earnings, welfare participation, or amount of government assistance after an average of 5 years since random assignment, end quote. The American Economic Review, the official journal of the American Economic Association, reached similar conclusions about the same federal program. Quote, no consistent detectable impacts on adult economic self-sufficiency or children's educational achievement outcomes, end quote, from the movement of thousands of people into higher income neighborhoods than the ones they came from. The Quarterly Journal of Economics, the oldest American journal in economics, likewise concluded that, quote, the changes in neighborhoods induced by MTO, Moving to Opportunity Program, have not affected the employment rates, earnings, or welfare usage by a statistically detectable amount for household heads, end quote. In addition to these scholarly journals, a study published by the U.S. Department of Housing and Urban Development, HUD, was based on research that same program, which, quote, followed more than 4,600 very low-income families in 5 U.S. cities over a 10 to 15-year period to examine the short and long-term effects of moving to low-poverty neighborhoods, end quote. Its conclusion was, quote, no discernible benefit to economic self-sufficiency, employment outcomes, and risky and criminal behavior for adults and children was observed as a result of moving. Similarly, moving had few positive effects on educational achievement for youth, end quote. Nevertheless, Secretary of Housing and Urban Development Secretary of HUD Sean Donovan in 2013 vowed to help urban blacks relocate to suburban neighborhoods where they can have access to good schools, safe streets, jobs, grocery stores, among other things, end quote. Secretary Donovan claimed that realtors and landlords still discriminate against blacks. African Americans, Donovan said, quote, are being denied their freedom of choice, end quote. According to Investors Business Daily, quote, earlier this year, HUD broadened the authority of 2 anti-discrimination laws, the Fair Housing Act and the Equal Credit Opportunity Act, making illegal any housing or credit policy that result in disproportionately fewer blacks or Latinos receiving household or home loans than whites, even if those policies are race neutral and evenly applied across all groups, end quote. Here, yet again, we see the implicit assumption that there would be no disparate outcomes unless there were disparate treatment. Moreover, that assumption seems almost impervious to evidence. One major difference between people sorting or unsorting themselves on the one hand and government officials sorting or unsorting them on the other hand is that people who sort or unsort themselves receive both the benefits and the costs of doing so. But government officials receive neither the benefits nor the costs of unsorting other people, and so many persist in the process in utter disregard of benefits or costs that fall on others. Indeed, the political costs of admitting to having inflicted socially counterproductive policies are a powerful incentive to keep on inflicting those policies and ignoring or denying their consequences. It would be wrong to say that there have been literally no benefits at all to anyone from government-subsidized or government-enforced sorting of people. While some studies have found some benefits to some segments of the low-income groups placed into middle-class neighborhoods by the government, these have seldom, if ever, been of the scope or magnitude envisioned when these programs were instituted. More fundamentally, negative consequences to the pre-existing residents of the communities into which they have been placed are seldom, if ever, mentioned, much less measured in these studies. It is as if any benefit, however small, to the new residents automatically outweighs any costs, however large, to the pre-existing residents. Disparate impact in employment. Although disparate treatment of individuals because of the group to which they belong is what is meant by discrimination too, this is not always easy to prove in a court of law. Nor does anti-discrimination law, as applied in American courts, require such proof. If a given prerequisite for employment or promotion, a high school diploma for example, has a disparate impact on some group, such as ethnic minorities, then the burden of proof falls on the accused employer to provide a justification of the requirement or else be judged guilty of discrimination. This process represents a major departure from American legal principles in both criminal and civil cases, where the burden of proof is usually on those making an accusation, rather than expecting the accused to prove their innocence. There are serious practical consequences of this very different legal standard in civil rights cases. There are costs to both employers and workers seeking employment when the assortment and proportions of employees differ from the assortment and proportion of groups in the surrounding area. For the employer, the fact that a charge of discrimination can be made solely on the basis of statistics about his employees, even without a single flesh and blood human being actually claiming to be discriminated against, means that employers can be put through a costly and time-consuming legal process that can drag on for years, consuming millions of dollars in legal costs alone, quite aside from costs imposed if this uncertain process leads to an unfavorable verdict. For example, a case charging the Sears department store chains with sex discrimination cost the company $20 million in legal fees and took 15 years to resolve through the federal courts, without the government having to produce even one woman from any of Sears' hundreds of department stores around the country claiming to have been discriminated against. Statistical disparities alone were sufficient to keep this costly process going for more than a decade. In the end, Sears prevailed in the appellate courts. But few employers are in any position to sustain such financial costs for so many years, all the while operating under the public stigma of discrimination accusations that can affect public opinion and the sale of the company's products. Most employers, including large corporations, find it expedient to settle such cases out of court, even when they have not violated anti-discrimination laws, and the number of such settlements is then used by critics to claim that employment discrimination is widespread. In 2012, for example, PepsiCo paid more than $3 million to settle a charge by the Equal Employment Opportunity Commission that the big soda and snacks company's use of criminal background checks was discrimination against blacks. This was a bargain compared to the cost to Sears of fighting a charge of discrimination against women, even though Sears eventually won the case. Moreover, having a charge of racial discrimination hanging over PepsiCo for years, while the case dragged on through the federal courts, could have cost more millions as individuals and institutions decided to buy their sodas and snacks from some other company. In short, the outcome of disparate impact cases does not necessarily depend on either the quantity or the quality of the evidence. By the time of the PepsiCo settlement, an empirical study had already shown that companies using criminal background checks tended to hire more blacks than companies which did not use such checks. The crucial factor in such cases is not the trial, but the costliness of going to trial, both in legal fees and in the loss of business due to bad publicity. The only way for the accused to win in any economically meaningful sense is for the case to be thrown out of court instead of going to trial. Rarely does a judge refuse even to let a case go to trial, though that did happen in 2013 when the evidence presented by the Equal Employment Opportunity Commission was called by District Court Judge Roger Titus laughable because of its, quote, mind-boggling number of errors, end quote, and because of the inconsistency of the EEOC's lawsuit against the company for using criminal background checks on job applicants when the EEOC itself uses such checks. The implication of the use of a disparate impact basis for costly lawsuits in civil rights cases does not end with employers. Workers can also be adversely affected, and not just with reduced employment opportunities for black workers who have no criminal record. When a federal agency can so easily make charges of discrimination on behalf of workers from racial or ethnic minorities, charges that can be costly and time-consuming to defend against in the courts, or charges that can force costly settlements out of court, that reduces the value of hiring black or other minority workers, even when their job qualifications are equal to the job qualifications of other workers who present no such legal risk. Employers therefore have incentives to locate their businesses away from concentrations of minority populations so that they will not be as legally vulnerable to costly charges of discrimination if their workforce does not end up with the same demographic makeup as that of the surrounding population. Japanese firms seeking to find locations for their first businesses in the United States have specified that they do not want to locate near concentrations of blacks in the local population. American firms that do the same thing, being more familiar with both the legal and the social atmosphere in the United States, may be less likely to leave a paper trail. Nevertheless, this raises the question whether anti-discrimination laws, as applied in the court, provide incentives to discriminate against racial minorities, as well as incentives to not to discriminate, with their net effect being uncertain. Many observers who see racism as both widespread and widely effective in the job market fail to account for the fact that employers in competitive markets have actively sought out black workers, even in places and times where racism was rampant and undisguised, such as in South Africa during the era of apartheid, under a white minority government openly proclaiming white supremacy. Similarly, black American workers were sufficiently in demand more than a century ago in the Jim Crow South that the organized attempts of white employers and landowners to suppress black earnings often collapsed under the pressure of that demand for black workers and sharecroppers. Northern white employers sent recruiters into the South during the Jim Crow era to recruit black workers on such a scale as to cause many laws to be passed in the South restricting the activities of these recruiters by charging them licensing fees and imposing other restrictions, and with serious penalties for violating these restrictions. This clearly indicates a strong demand for black workers in both regions of the country. Within northern communities, the demand for black workers was sufficient in the 1920s to cause Henry Ford and his executives to establish connections with clergy in Detroit's black community in order to get their help in sorting black job applicants. Similar arrangements existed in Chicago and Pittsburgh. The Ford Motor Company was, in effect, seeking low-cost access to knowledge of individual qualities in order to judge each individual individually, instead of having to rely on information about group characteristics. In short, racism has not been sufficient to prevent a demand for black workers in a competitive market. It would be painfully ironic if anti-discrimination laws have been among the factors which reduced that demand in later times. Intentions, whether good or bad, do not predestine outcomes. All right, that's the end of Chapter 3. We will continue in this series on Adam Smith's Discrimination and Disparities with Chapter 4, The World of Numbers. So until then, this has been Mike, signing off.